Guys, welcome back to Law News Network. I'm Heather Hansen, and our next guest is Sharon Meisler. She is a partner in one of the top criminal defense firms in the Philadelphia region, AMS Law. She's been a criminal defense attorney for 33 years, and during her career, she has represented various clients facing the death penalty. She also has served as a national trainer for other attorneys handling death penalty cases. I'm so excited to have Sharon here with us today to discuss these cases. Good morning, Sharon.
Good morning, Heather.
Sharon, I wanted to talk to you about both cases that we have going on right now, both the John Valerio case and the Marcellus Williams case. So let's start with the John Valerio case. That case was actually tried back in the 80s, and he was convicted in the 80s, but now they're having this retrial based just on the death penalty sentence itself. How common is it to just have a case retry on the sentencing part?
It is not uncommon. Usually, if the appellate courts are going to find an error, they will find an error in the sentencing aspect of the case.
Now, so they would oftentimes go back and retry just the sentencing aspect of the case?
Yes. In fact, in many cases, you have to impanel a whole new jury.
Now, in this case, that's obviously the case because it's been so long since that first jury. But I guess, by your answer, sometimes you go back and retry the case, but you get the same jurors back again?
Well, what can happen is, what's supposed to happen is you try the case in front of the jury. The jury decides whether or not the person is guilty. Then they decide whether or not death. If there's any kind of error and it has to come back, it's a new jury. So that's what I mean by it's a different jury. It's because it's not the same jury that was there for the verdict of guilty.
In a case like this one, the reason for the overturning the death penalty is because the instructions that were given to the jury were vague. They said that one of the things that you could base a death penalty sentence on is depravity of mind. How important do you find in the cases that you're working on that the jury instructions on the law becomes during the death penalty phase?
They're probably the most important instructions in the criminal justice system. Any time that we're talking about death, I mean, let's just stop and think about that. You can't exonerate an erroneous death penalty finding because the person's dead. Where we're hearing about all the DNA that's exonerating people, we can release them. You're dead, we can't release you.
Right.
So people really dot their I's and cross their T's. And one of the reasons is once you talk about death, whether we're talking about death penalty, just murder, and I don't mean to belittle murder, but a non-death penalty murder or even a manslaughter case. Once you're talking about death, you're talking about passions, you're talking about prejudice, you're talking about arbitrariness. And those are the three things that we try and remove when a jury is deciding, is this one of those rare cases where the death penalty should be imposed? And when you look at how many murder cases there are and how many actual capital murder death penalty, in the law we like to clean it up and call it capital,
right.
But it's a death penalty case. When you look at how many murders versus how many death penalty cases there are, one of the reasons we do that is because not every murder is death penalty qualified.
In cases like the John Valerio case, do you, during the penalty phase of the case, when we're talking about aggravating and specifically mitigating factors, do you tend to call the defendant as a witness to try to explain some of these things to the jury?
It's very case specific. You may be dealing with somebody who has mental health issues, and in some states, there's no requirement they have to be medicated. That you may be dealing with somebody who is intellectually challenged, who may be, the old term was mentally retarded. They may be above that level, but they may not be able to speak in front of a group. The reason that you usually have two attorneys on a death penalty case is one concentrates on the guilt, not guilty aspect, and the other attorney concentrates on the sentencing aspect, and that second attorney hopes that their work never has to be shown in front of anybody.
Right. Right. And when you're talking about the sentencing aspect, I guess psychological, to your point about psychological situations, psychological evaluations become part of the evidence that's presented to the jury. This time delay from the 1980s until now, how does that impact the ability to put on that second part of your defense and put on everything that you want to say during the death penalty part of the case?
These attorneys are probably jumping through hoops like crazy. One of the things they may be doing, and I don't know John Valerio and I don't know these attorneys, but one of the things they may be doing is trying to resurrect school records if they didn't have them originally. There may have been IEPs, individualized education programs. The psychological testing is one part of it. There's also psychiatric testing. Was there ever psychiatric testing done for him in other cases? In the article I read, it says that he has a prior felony conviction. There may have been a pre-sentence report done, and part of that may have been a drug and alcohol evaluation, a psychological, psychiatric. Both sides have their hands really full trying to go back and resurrect a lot of testing so that they can compare it to current testing. If he has mental illness, well, was he being treated properly at the time of the incident? Was he being treated properly at the time of the trial? Was he too emotional to testify at the original sentencing hearings? There are just a lot of issues that have to be resolved here, and both sides are going to have to work really hard to present it not only to the jury, but in a manner that's going to make a layperson understand the aspects that each side wants to portray.
Having served that many years on death row, so John Valerio has been on death row since he was convicted in, I think, 1988. Does that make it more or less likely, if you were representing him, and I know you only know a little piece, but does that make it more likely that you would actually present him as a witness because in those years perhaps he has been rehabilitated and treated and may present better than he would have back at the time of the crime?
If Nevada's death row is like most states' death rows, it's very isolating. It's not the kind of thing that you could have a black and white answer. You'd have to sit there and talk to him. I've met plenty of death row inmates who have really used their time well to learn, take courses to improve their minds, to teach younger inmates, don't do what I've done. I've also seen inmates who are on death row. There was a young man. He had been on death row for 3 years. He was 22, and I was there to handle his involuntary mental health commitment, because you don't know how death row per se is going to affect somebody.
So it really is a case-by-case basis for you as the lawyer to determine how that's going to impact their ability to present to a jury.
Yes, it is. Just a quick explanation for your viewers. When you walk into a maximum security prison, 9 times out of 10, it is so noisy that for me to speak to the person 3 feet away, I'm almost yelling. When you're on death row, you can whisper to people 15 feet away.
Wow, big difference then. Big difference.
There's a definite isolation factor that is involved in it.
Let's talk a little bit about the Marcellus Williams case, because that has been getting a lot of press today as well. Marcellus Williams is scheduled to be executed tonight at 6 o'clock. He is alleged to have killed Felicia Gale in a very dramatic murder with a knife, stabbed her multiple times, according to the jury that convicted him. Now the attorneys for Marcellus Williams have filed multiple appeals based on DNA evidence. First, Sharon, I just want to ask you about DNA evidence because we hear so much about it. Has there been such great advances in the science that DNA evidence has become more and more a factor in exonerating these types of cases?
Absolutely.
Yeah, and so, go ahead.
I'm sorry. And one of the things is, where was the DNA found?
Yeah.
You know, if the DNA is found in her apartment, where was it found? Was it found, in the bathroom? Was it found on her body? Was it found on the murder weapon?
Yeah, let me tell the jurors and the viewers and you just a little bit about what we're hearing about this case. They're saying that there was DNA found on the knife, the murder weapon, that was tested against Marcellus Williams, and there was not a match. There also was skin found under the victim, Ms. Gale's fingernails, that was not a match to Marcellus Williams, and there were hairs at the scene that were not a match to Marcellus Williams. Now, the other evidence, excluding the DNA evidence, but the other evidence was presented at this trial, and the jury still convicted him. But the DNA evidence now, do you have a sense of why the courts would allow the DNA testing to happen, allow them to go through this entire process, and now when they find out that the DNA is not a match, still proceed with the death penalty? It's confusing to me.
The problem is, just like when we talk about a jury not having prejudice or passion or arbitrariness in making their original decision, you still have that in politics. You have it in certain legal decisions. Not being familiar enough with what happened with Mr. Williams, maybe it's a political issue. Maybe they don't want to open it up. I don't know. I can tell you that the prosecution has an absolute right to seek justice, and therefore they may feel that this is the correct thing to do. The defense has an absolute obligation for zealousness. I might, not involved in either side, not wearing a black robe. My feeling is, before we kill somebody,
right,
let's have a hearing. Let's make sure we're doing the right thing. We can't correct it afterwards, guys.
Well, and that's my sense of it, Sharon. So apparently there was a similar crime nearby at the same time, and they have the knife from that victim as well, because that knife was also left behind in the victim's bodies. And one of the things defense wants to do is compare the DNA from that crime to the DNA from this crime. And apparently, per everything that I've read, it's something that has not yet been allowed. And to your statement, why not try that before we put someone to death, just to make sure that it's not DNA that's different? How often, so many people are calling and reaching out to Governor Eric Greitens, who's the governor of Missouri, asking him to grant Marcellus Williams clemency and at least give some time for this additional testing to happen. How often are those types of outreaches and petitions and public outcry successful?
They're not done that often. I can't give you a percentage, but they help. There's a case in Ohio, Tyra Patterson. David Singleton is representing her, and there's no doubt in my mind that part of the reasons why Tyra is finally getting a hearing is because of the public outcry about that matter.
Sharon, we're getting some questions from our viewers. Here's a question from Caper, and I'm sure that this is something that keeps you up at night. She's asking whether you ever think, was there a mistake? If your client gets the death penalty, do you ever wonder, was there a mistake? Do you ever stay up at night worried about the fact that this person's being put to death for something they did not do?
Yes. There's a reason why our segment of the profession is one of the highest rates of suicide and one of the highest rates of substance abuse.
Wow.
When we walk into a courtroom, sometimes it's just us against literally the entire state, and that person's liberty's in our hands. That's not something that any qualified criminal defense attorney forgets.
Yeah, it's got to be. I mean, we think civil attorneys think our jobs are stressful and we're dealing with money, but you're dealing with life and death decisions, and that's certainly something that is challenging, to be sure. How do you counsel? I know that you counsel younger lawyers and teach people how to do death penalty cases. How do you counsel them? How do you counsel them to deal with that aspect of the case, the impact it has on your own emotions?
The standard I give them is, at the end of the case, when you are sitting there by yourself, look inside yourself, and is your woulda, shoulda, coulda file empty? If you've done everything you can, then somehow, some way, you move on. And the most important thing is, I don't care if you win, you lose, you come back into work the next day. You do not take the day off, because the next client, the next file is waiting for you. And once you get back into that kind of routine, I wouldn't say it makes it easy, but it makes it easier as to whatever happened in that case.
Well, Sharon, few lawyers do what you do, and so I so appreciate you giving us your time and your insight into these specific cases. Thank you so much for being with me today. I know you're across the country there, so I want to thank you again for making the time.
Sure thing. Thank you for inviting me.